on the abortion side of things, Florida has a good reputation, right? But there are a lot of states that don't have as good of a reputation. So if another state has some cooperation with pro-life centers, and then that cooperation faces a challenge like the one Florida is starting to, we need to A, know about it, and B, know what to do about it.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering a Church Autonomy Doctrine ruling out of the Fifth Circuit. Then we'll talk about a pending law in California involving parental rights in medical decisions for their children. And we'll finish with a quick overview of a proposed law in Florida that would defund pro-life pregnancy centers. So a lot to cover, especially on this first issue. So we're going to start in the Fifth Circuit. We've talked a lot on this podcast about the Church Autonomy Doctrine, especially in recent months. It's been coming up in a series of important cases in the circuit courts. Many who are in this area will remember that it was also spoken about at length in Justice Thomas's concurring opinion in the Wisconsin Catholic Charities case earlier this year. And so we don't need to do much remedial overview here, but our listeners will know that the Church Autonomy Doctrine is rooted in the religion clauses of the First Amendment and essentially prevents the judiciary from ruling on the internal affairs of a church. So while that seems pretty straightforward, there's been some debate that we've been covering in some other recent cases over how broadly the doctrine applies. Is it especially procedurally, right? Does the doctrine act as a jurisdictional bar against a court deciding a case in the first place? Or can it only be raised as an affirmative defense once litigation has already been initiated? That's not really a resolved question yet, how broad or narrow the application is. So this case here in the Fifth Circuit continues that conversation, I think really contributes to it. So this was a recent defamation lawsuit. It was brought by a Baptist pastor who had been fired. He brought the lawsuit against his former employer, the Baptist Church. And the Fifth Circuit ruled in this case that the Church Autonomy Doctrine is more protective than a jurisdictional bar and dismissed the pastor's claims. So the pastor here, he filed a lawsuit against the North American Mission Board of the Southern Baptist Convention. The board terminated his employment for failing to successfully, these are quotes from the case, penetrate lostness, make disciples, and plant churches. So the court wisely here decides that, well, in order to rule on this defamation case, the court has to dig pretty deeply into these terms and decide whether the pastor performed satisfactorily, but performed what satisfactorily, right? What does it mean to successfully penetrate lostness among a flock or make disciples among the people in the church? These are obviously doctrinal religious questions. So the Fifth Circuit here ruled that the Church Autonomy Doctrine prevents the court from ruling in the fired pastor's favor in this case. So I want to do a couple of things here. First, it's worth noting quickly that the opinion does clarify, we've had this before in other cases, that the doctrine applies even though this Baptist organization doesn't have a typical hierarchical structure, right? If you're talking about church autonomy, a lot of the origin cases here, like Kedroff and the ones that followed it, involved Orthodox churches who had a very typical structured hierarchy, right? You have maybe the metropolitan or the patriarch in Constantinople or the patriarch of Moscow, and you're trying to figure out, well, is it the church in Russia? Is it the American bishop? Is it the local priests? Like who has the final say over these things? And the courts would often hesitate to get into these doctrinal questions. But here you're talking about a very different association, right? You don't have a clear delineation of priests and bishops, and the Fifth Circuit saying that's not necessary to have the Church Autonomy Doctrine apply. The court says the Church Autonomy Doctrine is triggered by the subject matter of the dispute, right? A religious or doctrinal question, not the organizational structure of the disputants. So worth pointing out here that it doesn't have to look like a hierarchical church for the Church Autonomy Doctrine to apply. That seems to be more and more what the court has clarified in recent cases, even though the origins were built around hierarchical church disputes. So what I want to do here for a minute is go into the quotation I just mentioned at the beginning from the Fifth Circuit, stating that the Church Autonomy Doctrine is more than a jurisdictional bar, because in our maybe overly black and white analysis, it's typically looked at as, is this a jurisdictional bar where if the Church Autonomy Doctrine is implicated, then there can be no more case, it has to be dismissed from the outset? Or is it an affirmative defense where the lawsuit's filed, they proceed a little bit, and then the defendant raises, well, church autonomy, that's our defense to why we did what we did, and then it gets dismissed? So I think what this case here seems to hint at is that's a little bit of a false dichotomy. There are other options, maybe even broader than just saying, well, it's a jurisdictional bar. Judge Oldham's opinion is worth reading in a little more length. So I'm going to just read a few sentences that lead up to that sentence about it being more protective than a jurisdictional bar, and then we'll discuss a couple of pieces of it. So the opinion says, where the church autonomy doctrine applies, its protection is total. That is because the doctrine is a constitutional immunity from suit. Like other immunities from suit, church autonomy must be resolved at the threshold of litigation. Like other immunities, church autonomy can be raised at any stage of litigation. Abridgment of the church autonomy immunity imposes irreparable injury on the religious organization, so its denial is subject to an immediate interlocutory appeal. For those who are not specialists, that means if the trial court says no, church autonomy doctrine doesn't apply here, we're moving on to the merits of the case, you can appeal immediately. You don't have to wait for that trial case to finish before you can appeal. Court goes on and says, church autonomy doctrine applies equally in state and federal courts, and in federal court, it generally produces a judgment on the merits with prejudice, entitled to res judicata in state courts, preventing repetitive litigation. The church autonomy defense is therefore more protective than a jurisdictional bar. I think this is right. I think this is the proper and logically consistent view, right? Because if the church autonomy doctrine read broadly means that, look, secular courts have this domain of secular, civil, criminal, legal disputes, and then you have church law, church doctrine questions. They're separate spheres. Secular courts don't have the ability, they don't have the power, the jurisdiction to be involved in that world at all. That means all of the things that I just read in that opinion, right? It means you can't look into it, not in state court, not in federal court, because it's outside the jurisdiction of federal courts. If the federal court decides, yes, church autonomy applies under the First Amendment, you can't go relitigate this case under, rebranded in the state court. It just fully bars secular courts from hearing these types of cases, full stop. So I think it's a really good articulation of the church autonomy doctrine, a little more complete than what we've seen in some other cases. And basically, if you follow what the Fifth Circuit here says, I mean, secular courts just can't look into or resolve these kinds of religious or doctrinal questions ever. So then in that case, it shouldn't matter whether it's raised as a defense, whether it's raised at the very beginning, or whether, the church messes up and raises it when we've already started. If the court doesn't have jurisdiction, it can never have jurisdiction, no matter when you bring this up or forget to bring it up, what stage it's raised at, etc. So if the dispute involves a church autonomy question, the court should never have the ability to proceed and look into it. As the Fifth Circuit said, this is a threshold question. Without an affirmative answer that it is not a church autonomy issue, there's no jurisdiction to look into this. And that jurisdiction would always fail if you can prove church autonomy applies, right? We've seen other hints at this. The Billard case, was that 2 years ago now, out of the Fourth Circuit, it was a ministerial exception case, but that's basically a branch of church autonomy. The Fourth Circuit there held that the ministerial exception cannot be waived, which I think is an interesting argument that lends support to this broader reading of church autonomy, right? In the Billard case, actually in the trial court, if I remember correctly, the church in Charlotte, or the school in Charlotte, actually waived their ministerial exception defense and proceeded on other arguments. And then when the trial court resolved it unfavorably and there was an appeal to the Fourth Circuit sua sponte on its own said it doesn't matter whether they waived it or not, they're not allowed to waive it, because if it's a ministerial exception, we can't get involved in decisions involving the hiring or firing of ministers, even if the school wants us to, right? So I think that's a really important kind of augment of this argument, that church autonomy and all of its different offshoots, if they apply, the courts can't get involved, even if both parties want them to, because it's just outside the scope of what they are designed to decide. One thing I want to note briefly, this is a less legal technical point and more just a larger political cultural point. I think it's kind of noteworthy that church autonomy has been growing. We've seen it in several circuit cases, Huntsman out of the Ninth Circuit, Billard, the ministerial case in the Fourth Circuit, now this out of the Fifth. Justice Thomas's concurrence in Wisconsin Catholic Charities, it looks like a case where eventually the right set of facts and circumstances will come up where we might see another Supreme Court case to start to clarify how broad, how it functions, how the Church Autonomy Doctrine works. So I think it's important here that the Fifth Circuit, first of all, is an influential circuit. There are a couple of quote unquote heavy hitters among like the intellectual originalist crowd. Judge Oldham is one of them. Judge Ho is another one. Decisions of Fifth Circuit court judges tend to carry a lot of weight, especially in other circuits that have majority conservative leaning, originalist leaning justices. So I think that this is an important case to add to the body of discussion around the Church Autonomy Doctrine. And then on a related note, I think in particular, it's relevant and interesting to me that Judge Oldham is the one who wrote this opinion, because again, this might be a SCOTUS-worthy topic in the near future, and all the DC legal chatter does throw Judge Oldham's name around as a future SCOTUS appointee when a vacancy comes up. So interesting. Judge Oldham's an important judge on an important court, and this is an important carrying forth of the church autonomy jurisprudence. So I'd love to hear what you have to say on this, Joseph.
Yeah, thank you for a great kind of summary of what's going on here and getting into some of the conversations surrounding this. And I do want to add just a little bit more detail into that jurisdictional bar label and conversation that you brought up. So in this opinion, Judge Oldham noted that when a court decides that it can't rule on a case because of the Church Autonomy Doctrine, that's a strong enough decision to prevent future repetitive litigation. And that is how the Church Autonomy Doctrine is, as you noted, stronger than a jurisdictional bar with this understanding. Because basically applying church autonomy in a dispute would render that dispute res judicata, a matter judged. So as a result, because of that res judicata kind of identification, a plaintiff wouldn't be able to bring this same claim into a different court. They can't say, oh, we lost in the federal court, so we'll just try to go to an estate or something like that and start doing this forum shopping. And that's different from a typical jurisdictional bar, because with a standard kind of subject matter jurisdiction issue, the dispute can just be heard in the correct court. I don't know if this actually would happen, but just kind of for an illustrative example, let's say a family court gets some case that they ultimately decide, no, wait a minute, this is a tax question. It should be in a tax court. Ordinarily, that jurisdictional bar doesn't say, well, now nobody can hear this case. It just means now it's going to go to the correct court. Here, with this understanding of the Church Autonomy Doctrine, applying it would have effectively finished off the case kind of across the board, and it would prevent that sort of forum shopping that sometimes gets brought up.
Yeah, I think that's a good point. And I think I would especially say that one of the places that this, subject matter jurisdiction dismissal happens the most is just the federal state question, right? For most of the people listening to this are likely lawyers, and they did their civil procedure class in 1L year, and they remember at least echoes of this, right? But subject matter jurisdiction, to get into a federal court, you need at least either there has to be a federal question, right, a constitutional or federal statute at play, or you need to have a certain mix of defendant and plaintiff from multiple states that justifies federal jurisdiction. So you have cases often where the federal court is going to dismiss a case and say, no, we don't have jurisdiction over the subject matter because this is a state question, right? There's no federal claim. There's not a multiplicity of states represented by the parties here. So we're dismissing, but it's not because we can never hear this type of case. It's in this particular case, you haven't met the bar for jurisdiction. But you're right. This articulation of church autonomy is something much different than that. It's, if anything, it's saying, yeah, this is not the right subject matter for our court or for any federal or state secular court. Go to your ecclesial body, right? So you're right. It's much stronger than a typical like motion to dismiss for lack of subject matter jurisdiction in a normal federal case. It's a great point.
Great. Yeah. So with that, we'll move into our last two updates. We're going to discuss some problematic state laws. For the first one, we're going to discuss a new California statute that expands what non-parents are allowed to make medical decisions for minors. So this law, which is the legislature passed it in California, so now it's awaiting Governor Newsom's signature, so it's not enacted yet, but it seems like it's heading that way for sure. It's called the Family Preparedness Plan Act. Basically, what this act does is it permits more relatives to a minor other than his or her parents who can authorize medical decisions for the child. So now those within the fifth degree of kinship, so that's grandparent, aunt and uncle, great grandson so on and so forth, and also great great grand, so on and so forth. So a lot more people other than a child's parents now are authorized in California to make medical decisions for them. Remarkably, the original, an earlier version of the bill would have added non-family members, like teachers and neighbors, to also authorize decisions for minors, to authorize medical decisions for minors. So the kind of motivation supposedly behind it, the bill claims that it's designed to protect kids when their parents are removed for immigration violations. However, in effect, really it's shifting a core fundamental right from parents to non-parents, and it's removing this basic ability to be the only decision maker for a child's medical uh, activities. California law already has some carve-outs that make it possible for a minor to obtain an abortion without parental consent, but those aren't unlimited. So this law kind of brings up some more questions of not only broadly medical activity, but is this even easier now for a minor in California to attain an abortion without any parental knowledge or consent? And as we've discussed before on this podcast, the right to direct the upbringing of your children, which certainly includes medical decisions, is a fundamental part of the right to religious free exercise. Right? We generally cover religious liberty cases here, and the capacity to make decisions for your child and be the exclusive decision maker is a big part of that First Amendment right. Um, We've also noted before in this podcast on other similar cases how there's a juxtaposition in these types of removing parental consent requirements from other kind of common practices, like in schools. Even just to do something like get aspirin, you probably need a note from home. But then the same state will say, oh, but if you want to do something much more drastic, somebody other than your parent can give you that authorization. So that does kind of start to play the hand of, is there an ideology behind these sorts of things, and what the actual effect of removing parental requirements is. So Frank, I'd love to hand it off to you for your insights, particularly for kind of some existing precedent on how the Constitution works to protect parental rights.
Yeah, I've just glanced through this statute, or the not statute, but the proposed bill, and I mean, the safeguards purport to be there, right? It's the idea isn't just now, it's not just a parent, but if the great aunt calls the school and says, yes, I authorize this, you can do it. That's not the point. The point is for absence, right? If the parent is absent at a time that there's a need for a medical decision to be made, that someone else can be approved to do that. The issue, or at least, and again, I'm not an expert. I haven't been following all of the procedure and the debates around this law. But one of the things that jumps out to me is what do we mean by absence? How long does it have to be? What's going on here? Because it does say that, like, where's the language? The bill would authorize a court to appoint a custodial parent, right, some other family member, and a person nominated by the custodial parent as joint guardians of the person. If the custodial parent will be temporarily unavailable due to specified circumstances, including immigration-related administrative actions, right? My concern is that, like, you mentioned the abortion issue, but there's also, I mean, I would imagine particularly in California, but we've covered a lot of cases where there are the beginnings of medical or psychological interventions regarding transgender ideology that are happening in schools, sometimes without parents being notified anyway. And if you have a parent who's opposed to whatever medical procedure or decision making is going on, how absent do they really have to be before you're going to appoint someone else beside the parent to make the decision? Again, I'm not an expert on this type of law, but it does kind of raise red flags when you're creating a regime where it becomes easier to allow people other than the parents to make parental decisions. It just kind of, we'll keep following this, especially if it gets signed into law. But my first kind of gut reaction is to be cautious when you see something like this. Now, it's not exactly on point, but one of the things that this brought up in my memory was the Troxel v. Granville case, which, again, lawyers will remember from law school. This is a 2000 case where the court held that there's a fundamental right under the 14th Amendment for a parent to oversee the care, custody, and control of a child, right? So obviously, if it's a fundamental right, you can have compelling interest. There are certain times where there's a reason that the parent can't oversee the care, custody, and control of a child. For example, you have children and youth agencies when parents are drug addicted or abusive, then there's a compelling interest to step in and have somebody else make those decisions. But the general rule is it is the parents and nobody else who makes these kinds of decisions. So, and the Troxel v. Granville case was a weird one. If I remember correctly, it's been several years since I studied it, but I think it was one of the parents was deceased, and that parents, so I think it was the dad who died, so it was the paternal grandparents who wanted visitation, and then there was this law in the books that they could file something in court saying, well, it's in the best interest of this child that the grandparents get visitation over the objections of the parent who was alive and had custody of these kids. And that's what led to this case. I might be a little off on the facts, but that's the gist of it. And the court said no, like you can't have an ordinary regime where somebody other than the parent can just go to court and file for rights to visit. It's up to a parent to decide who should be visiting with their child, period. You don't get to just step in because your child, the parent, is deceased and you want to just be that the replacement parent, as it were. So there's a quote here I just want to read briefly from the Truxell case. The state was Washington here. So Washington's breathtakingly broad statute effectively permits a court to disregard and overturn any decision by a fit custodial parent concerning visitation whenever a third party affected by the decision files a visitation petition based solely on the judge's determination of the child's best interest. A parent's estimation of the child's best interest is accorded no deference. So I think it's a kind of similar concern I have. I'm not saying it's right on point, but like, what would happen in California if you have a set of facts where, like, let's say a family with questionable or complicated immigration status, right? The parents are Christians and they don't want certain procedures done. And then dad ends up in an administrative hearing for immigration. Oh, court jumps in and like appoints the non-religious, pro-abortion aunt. And then all of a sudden she's making different decisions. Again, these are all hypotheticals. Maybe I'm grasping here, but it does concern me that this is a potential problem when you make it easier for non-parents to step in and grasp parental rights involving decision-making over children. All right, well, with that, I think we'll jump to our final topic, which we will be brief on because I don't have a whole lot to say for a couple of reasons here. It's worth highlighting just because every time something like this happens, it's worth calling it out. But this is a proposed law in Florida that was just introduced by a state legislator, a Democrat from the Palm Beach area, I believe, that would defund the pro-life pregnancy resource network in the state, ban it from receiving federal funding. So the proposed Florida law current Florida law, requires that the state's Department of Health contracts with pregnancy resource centers to ensure that new parents have what they need, especially when they're needy families, right, to support new babies and new moms. So the current law states that the Department of Health must work with this Florida Pregnancy Care Network, which is an alliance of many of the pro-life centers around the state, quote, to meet the pregnancy and parenting support and wellness needs of expectant parents and those with young children. Okay, so that's the current state of Florida law. This recent bill introduced by the state representative was just brought to the state legislature to repeal this law, which codifies that relationship between the Florida Pregnancy Care Network and the Department of Health. So if it were passed, the various pro-life centers affiliated with that pregnancy care network that support parents and children would lose access to that support from the state funding. So one thing I want to say is, first of all, it's just worth pointing out this is politically extremely unlikely to pass. These things always generate headlines, and rightfully so, because it's such bad optics to try to defund something that is literally just supporting, new moms, poor moms, babies in difficult situations. It doesn't actually affect the pro-abortion people all that much, except that it gives a pro-life alternative to people who actually want to have their children instead of killing them. But otherwise, it looks like political showmanship. From what I read, this Democrat state representative has a history of introducing pro-abortion legislation. This isn't the first time she's introduced something that did not pass on this kind of issue. I mean, Florida has passed a lot of pretty bold pro-life legislation over the past 3 years. The Florida House currently has an 86-32 Republican majority. The state Senate, 26-12 Republican majority. I'm not in Florida politics, nor are we a political commentary organization, but I think it's pretty safe to say that this bill is dead on arrival. But I think it's worth pointing these things out and to use them as teaching moments, right? To explain, like, this is not a war between like pro-abortion like Planned Parenthood versus some organization that's trying to, destroy all of the pro-abortion folks. These are pregnancy centers that do, prenatal care as well as postnatal care, as well as parental support and education. They do a lot of good work in the community, both for pregnant mothers and then once they have the babies. And so if we're going to have publicly funded programs at all, right, which there's a small government kind of question in there that I'm obviously not going to go into, but on the whole, I think it's pretty uncontroversial that if we do have publicly funded programs, we should fund programs that support the common good. Supporting babies and mothers in need is a good. And therefore, if you're going to have public funds flowing to anything, this seems like a good candidate for it, right? Last thing I'll note, there was a statement from National Right to Life noting that I thought this was an interesting point because usually, and I didn't check in if Planned Parenthood was involved with the influencing or encouraging this legislation, I don't know. But the National Right to Life noted that, listen, Planned Parenthood, which also often receives public funds, right, through Medicaid and other programs, they charge for their services, right? While the pregnancy centers under this Florida Pregnancy Care Network do not charge for their services. So beside the original point I made that, well, pro-life pregnancy centers support babies and mothers so they can live better rather than killing the unborn children. That point aside, these pro-life pregnancy centers seek to provide a service, which they're not charging for, rather than make a profit, which is what Planned Parenthood does. So I think it's just kind of an interesting note to end on for me that I think it would probably be fitting if you see organizations that run more like charities, these pro-life pregnancy centers, are fitting candidates for tax funding to do a good, rather than Planned Parenthood, who is often clamoring for public funding and is a for-profit entity that is, I mean, doing evil work. Add that in. But I think I will stop. Again, I don't want to make too much of this because I'm pretty sure it's going to die. But I'd like to hear your thoughts, Joseph, before we wrap up.
Yeah, like you said, it's unlikely to pass, just given the kind of makeup of the Florida legislature. But it is important to be aware that these types of efforts exist because not every state has the same kind of protections for life and culture of protection for life that Florida does, putting aside some kind of IVF and other related things that are a little bit less talked about in Florida, but have some more concerning legislation. But not to get in the weeds of that. On the abortion side of things, Florida has a good reputation, right? But there are a lot of states that don't have as good of a reputation. So if another state has some cooperation with pro-life centers, and then that cooperation faces a challenge like the one Florida is starting to, we need to A, know about it, and B, know what to do about it. So just knowing that these sorts of things exist, and in those states that are a little bit more in the ideological middle, again, putting aside the small government side of things and that assuming that these programs exist, it's important to know that these sorts of things can happen.
Yeah. Yeah, it's especially problematic when, and we saw this on in very different issue areas, right? But in the beginning of the Trump administration, when all of a sudden there were pretty bold movements to cut government funding to a number of NGOs and nonprofit organizations, in my opinion, for understandable reasons. That's my opinion, not Napa Legal's opinion, as far as I know. But that aside, the greater lesson is, yeah, it can quickly become a concern and a problem when an organization, even one that's doing very good work, becomes overly reliant on government funding, because government funding can come and go with changing political regimes. So that is a problem too big to tackle here and for another day. I think with that, we'll wrap this one up. So thank you for joining us, as always, for this episode of the Napa Legal Podcast. If you enjoy what we're doing and the content we're putting out, we'd always appreciate it if you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening from. And if you want to support our work, we would greatly appreciate it. You can go to napalegalinstitute.org and donate to support our many programs and endeavors, including this podcast. We hope you'll enjoy us, and you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. So we'll talk to you next week. Thanks for joining us, and God bless you.